So let me ask this question, like when there is a registered document, whether it is required that the document's execution must be proved before the court, whether it is required as such. The answer is no. When the document is registered, its execution need not be proved before the court. That is a general rule. But there are some exceptions for this rule. The exceptions are as follows. So when the document itself is a will, because for wills, registration is not mandatory. In such cases, when the document itself is not registered, how you cannot ignore proving its execution. That is first exception. And in cases where executant itself comes before the court and he says that and disputing the execution. So in such case, the execution have to be proved because the executant itself comes before the court and disproves the execution. So something is fishy and the court has to consider proving it. And the way in which execution can be proved are as follows. Like at least by one witness it can be proved, but generally it is executed by two witnesses. That is according to section 3 of Transfer of Property Act. So when it is executed by two witnesses, at least one of the witnesses is alive. Okay, consider this situation. It has been executed by two witnesses. Now only one witness is alive. In such case, we can ask one witness to come before the court and prove the execution. That is one way of doing it. And there comes the next section, that is section 68. And this section 68 provides an alternative method for proving the execution. Like when attested witnesses are not at all found, like it should be attested by two witnesses, right? When two witnesses are not at all alive, they both died. In such case, how execution will be proved? That is given under section 68. So now in this situation, handwriting of the attested witness or signatures can be used, okay, to prove the execution. That is given under section 68. And then comes section 69. So as per this section, when executant comes before the court and he admits that he is the one who executed it, then of course there will be no dispute, right, in such case, because the executant itself is coming before the court and admitting it was executed by him. Then there is no dispute. And then comes the section 70. So according to this provision, the person who had attested the document is not able to recollect, or he denies that he has attested, due to, it could be because of his old age, or due to some accidents or things that would have affected him not to recall, right? A good example would be the elderly person example. Elderly person comes before the court and says that I'm not able to recollect that I've attested the document because of my old age. He says before the court like this, and in such case the execution can be proved by corroborative evidence, okay, due to old age, or there could be different situations, right, not just the old age. So the person comes before the court and says, the executant, that I'm not able to recall or recollect. In such case, the execution can be proved with the help of corroborative evidences. Not just the corroborative, also circumstantial evidences can also be used to prove the execution. Now comes the section 71. So now if there is a document for which attestation is not mandatory, so in such case, how that document can be proved? That is the central issue. That document can be proved as if it was unattested, in a way that how an unattested document will be proved. Another question arises now, how such unattested document will be proved. In cases of unattested document, the document itself must be brought before the court and it should be proved. That is about section 71. And next comes the section 72. So section 72 deals with a comparison that the court makes. Like when the court needs to know the genuineness of the execution of the document, the court can compare the handwriting or sign or any seal. Also, it could also be finger impression, okay, by comparing it with another document, whereas the same sign or seal has been made. So basically, section 72 deals with comparison that will be done by the court in order to prove the genuineness of the document. So then comes the section 74. This section 74 deals with what documents could be categorized under public document. Firstly, documents of sovereign authority, official bodies, tribunals, public offices, and the documents that are relating to executive, legislative, and judiciary branches of the government. So these are the documents that that comes under the category of public document. Also, the documents relating to foreign country and any sort of private record, private document that is kept under the public custody, and pleadings which are accepted by the court. Those pleadings can also be considered as public document whenever when a diary a number is given to that, because now the court has accepted such pleading and it is under the public custody. Then such document can also be considered as a public document. Under the same section, under clause 2 of the provision, it has been private document has been defined. So what could be a private document? All documents other than the public documents are private documents. It is as simple as that. Whatever the document that is not public in nature, that will be considered as a private document. And now comes the section 75. So according to this section 75, it provides a procedure as to how certified copies can be obtained. Okay, so basically certified copy is nothing but a public officer is having a custody of a public document, right? So in such case, the public officer has right to inspect the document, and a person can go to the public officer and pay a required fee, and they can collect the certified copy from him. That is the procedure, and that copy that is obtained from the public officer will be called as certified copy. And according to section 76, we can presume that certified copy could be a good proof. Okay, certified copy is a proof regarding the contents of the document. In order to prove the content of the document, certified copy could be a proof. Okay, that can be submitted before the court and court can consider it. And now comes the section 77. Section 77 deals with proof regarding other official documents other than the documents that we had seen earlier. This talks about other types of official documents. So in order to provide proof of the following documents, it has to be certified by the respective entities. Okay, like when the document is a law or notification, order of a central or state government, it must be certified by head of the department. Only then the document can be proved. And in case of documents regarding a legislative proceeding, then it can be proved by journals of the legislature or any government order when the document is regarding a legislative proceeding. And in case of proceedings of municipal body, the document should be certified by a legal keeper. So whoever the person responsible for keeping that document, he has to certify, saying that this is a municipal proceeding document, and only then the court will consider.